We're live.
Okay. The first witness I have scheduled is Jared Bianchi, Deputy State's Attorney in Bennington County. And Jared sent out a proposed amendment.
Good morning, Senators. Would you like me to begin, or
Yeah, please.
Thank you, Mr. Chair, members of the committee. My name is Jared Bianchi. I'm a Deputy State's Attorney in Bennington County. I wanted to give you a bit more of my background today because I think it bears on how I come to be in front of you today. Prior to my recent move to Bennington County, I was employed by the Vermont Attorney General's office as an Assistant Attorney General for essentially the entirety of my legal career, which is now about 10 years long. In that role, I represented the Agency of Human Services and each of those constituent departments: mental health, DCF, Dale, etc. I did so in every kind of hearing, from administrative hearings all the way to the Second Circuit Court of Appeals. At one period, I was the Assistant Attorney General solely responsible for guardianship and Dale Act 248 cases. And you may be familiar with Act 248 as essentially the commitment process that occurs for a criminal offender, or a justice-involved person rather, who is not competent or is not sane due to an intellectual disability. So I have seen this issue from both sides of the fence, and I'm here to let you all know that this is a real problem that you're addressing with S89, especially with respect to very serious cases where indisputably violent people may be released back into the community with little in the way of supervision because they are not fitting into particular clinical standards or have been discharged after being stabilized. I did want the committee to know that we did provide, as part of my work on the forensic working group, another piece of potential legislation that the state's attorneys and sheriff's department does support, which takes a bit broader brush to reimagining the process for addressing justice-involved individuals, and creates a separate process specific to those folks. But we're here today in support of S89 because the third option, the forensic facility that S89 provides, is a move in that right direction, albeit one step of perhaps more that are necessary. It's a move in the right direction and creates a desperately needed third option available to high needs individuals. For the bill to truly have an impact in those most serious cases, those most concerning cases, we have proposed an amendment to be included. That amendment would make a modest adjustment to the criminal commitment hearing process that already occurs by making access to the forensic facility a component of that conversation. We would essentially be including this in the same conversation that the court has currently with respect to an order of non-hospitalization or an order of hospitalization. This would provide that third option, but only in the very narrow set of cases where a person is held without bail on a life or a very violent offense. So we see that as being a narrowly tailored approach. It would also require that setting be found by the judge to be the least restrictive appropriate setting for both their treatment needs and for the needs of public safety. But it does allow, we think, the necessary conversation for public safety to be considered by the judge who's deciding what ultimately will happen with that defendant. We do, all the data suggests that this would be a small population of those most serious cases, but in so doing would have a large impact on community safety in those most high needs cases. We've only begun discussing this with our other partners at, in the administration and in the executive branch. So I don't expect that they'll be able to respond fully. I've provided the language to also General Counsel McClin, and I'm happy to continue to have those conversations. And I'm hopeful that we'll get the committee's support and the support of those partners. So we do ask and are in support of S89 and would ask that you pass it, and especially with the proposed amendment.
Thank you. Other questions for Jared? I guess the obvious question, Jared, is the amendment would give the judge the ability to you to argue for the person to be held without bail in a forensic facility. And the court has the ability to order that if they find those three factors. Am I reading that?
Essentially, yes. It would be basically a third. So right now, a court who is having a commitment hearing has to determine whether any order is necessary concerning the person, and if the person is not competent or not sane, has to decide whether to place them in the custody of either Dale or DMH, and if so, on an inpatient or outpatient basis. This provides that third option if the very specific criteria are met as to the needs of the individual, the needs of the community, and also the severity. This would really only apply in those most severe cases. It's our understanding that we are talking about a very limited set of beds, and so this is really tailored to the most serious, most acute needs cases that we have right now.
Any other questions? Thanks, Jared, if you could hang in there.
Thank you.
Appreciate your testimony. At some point, I hope to get to the competency issue, but unfortunately, we're running out of time this year.
We understand that there will be further discussion, so thank you, Senator.
Oh, yeah. Jack McCullough is next, and I think I saw Jack in the committee room.
I am here. Thank you, Senator. I look great at this, right?
Where?
Okay. Okay, gotcha. Okay. Thank you, Mr. Chairman, members of the committee. I'm Jack McCullough. I'm the director of the Mental Health Law Project of Vermont Legal Aid. At this point, I think what I have is more questions than answers about this bill. And I just am having a hard time understanding what is hoped to be accomplished and how this solves a problem that we don't already have the capacity to address without this legislation. First off, I question what is the purpose of this legislation. Is it intended to separate people according to the level of danger they might pose, or is it to separate people who are in state custody based on what part of the system their cases started out, whether it's in the civil system or the criminal system? I can tell you that there are plenty of people who are held in one of the hospitals or at the Vermont Middlesex, the therapeutic community residents we have now. Plenty of people who have been determined to be a significant danger to themselves or others based on the ordinary Title 18 commitment process. And there are also plenty of people in the involuntary mental health system, either in one of the hospitals or somewhere else in the system, who have been determined to be a danger to themselves or others through the criminal process, but are not at the level of a highly acute threat to the public or to the people that they're confined with. And so for as long as we've been hearing proposals to open a forensic facility, I've had that question in my mind. What are we trying to do? Are we trying to separate the super dangerous from the less dangerous, or are we doing something else? And I think we need to have a good answer to that question before we embark on this. Second, it's hard for me to understand what this legislation gets us that we don't already have. The criminal division, in criminal cases, the criminal division has the ability to hold a hearing, and we do those hearings all the time. It's called a hospitalization hearing. The criminal division has the authority to hold that hearing for someone who's been found to be competent to stand trial or not guilty by reason of insanity. And if there's a showing that the defendant is mentally ill and is a danger to him or herself or others, then the court has the ability to commit that person either to a psychiatric hospital or to an order of non-hospitalization based on the court's determination of what level of, what type of facility is adequate and necessary to meet the person's treatment needs. And I think that this legislation says we're going to do that, but as I say, except for the fact that we're creating this new facility, there's nothing that it doesn't give the court any authority that it doesn't already have, with one exception, which I'll mention in a moment. And that's what I come to next. It's hard to understand when we first created the Middlesex Therapeutic Community Residence. The selling point was that it was to be someplace, it would be a locked facility where people could be held based on danger, but just people who did not need the hospital level care. Now we're getting into the proposal in one of the later sections of the bill, section 18 and 19, where the department would be charged with amending the regulations. Right now, the therapeutic community residence does not have the authority to do involuntary medication. Therapeutic community residence does not have the authority to do what in hospitals are called emergency involuntary procedures. Anything from brief hands-on to restraints, seclusions, or emergency involuntary medications. Those things are not available in a therapeutic community residence now, and I gather that part of it would be to give the therapeutic community residences the authority to do that. And so, yes.
So I just have a question. If the therapeutic community residences aren't currently allowed to do this, is the Vermont Psychiatric Hospital in Berlin the only place that's allowed to use these tools?
No, all the hospitals that, there's two ways to answer that question. For the people we're talking about, all the psychiatric hospitals have the authority to, there's a court process to go through for non-emergency involuntary medications. For emergencies, when a person is imminently posing a danger, throwing chairs around or whatever, not only do the psychiatric hospitals, but any hospital in the state has the authority to physically intervene and take what emergency steps are needed, up to including physical restraints or involuntary medication. So I think it's confusing about whether this is really going to be a hospital or is it going to be something else, and how is it going to be determined who needs to be in what kind of facility. With regard to placement, that brings me to my next point with regard to where a patient would be placed. There is a section that says that section 4 amendment to 18 VSA section 7618A1 that says that if the court issues an order of non-hospitalization, placing this person in the custody of the commissioner, that if the commissioner determines that treatment at a forensic facility is appropriate, then the court is required to place that person in the forensic facility without giving the defendant or the proposed patient a chance to argue that that facility is too restrictive and they should be able to be placed at one more level of restriction. And so that's a serious problem essentially to require the court to order whatever the commissioner says they want, instead of placing that authority in the hands of the court, with the court listening to the arguments on both sides of what kind of treatment setting is needed. So, as I say, more questions than answers. I think that's about what I have now. I haven't seen Mr. Bianchi's proposed amendment. However, I do not believe from the cases that we're handling, and these are cases that lie both in the mental illness and developmental disability categories. I do not believe it's accurate to say that people are being discharged into the community because they don't meet certain clinical standards. I believe that in the cases that I've been doing, when we get somebody discharged to the community, it's based on the fact that the state has failed to make an adequate showing that the person is a danger to him or herself or others, needs to be confined to protect the public. I agree that protecting the public is an important interest that we need to be doing. I don't think that this bill really accomplishes anything that's needed. I think that's
Well, thank you, Jack. I actually disagree. I think that the bill would accomplish taking some of the pressure off some of the facilities that are currently being asked to do things that they're not equipped to do. I think that the system itself, ever since Hurricane Irene, has been a disaster. And we've been kicking the can down the road for so long that we've gotten used to a system that is not responsive to victims, is not responsive to the needs of the communities for safety, and in many ways is not responsive to the needs of those who are committing crimes but found to be either incompetent to stand trial or not guilty by reason of insanity. I think the system is in shambles, frankly. And I think it's shown by the fact that what beds are available, where and how, and some of the other challenges that we've all heard about in our communities. So I think there is a need to at least have something at the top in those most serious cases.
Senator, if I may, just a moment, I agree with a lot of what you just said, and I agree that we have a situation that where the system is a mess, and I think the issue really is more an issue of capacity than what types of facilities are available. And I've been arguing for a while. You know, we have this proposal for a giant gold-plated new psych unit at Central Vermont Hospital, and I keep thinking that the biggest problem of our system really is that we have a grossly inadequate community system, and that's leading to a lot of the other problems we have, including the problems of people in emergency departments and people getting stuck in psychiatric units where if there was someplace for them to go, they could, they wouldn't have to be hospitalized. So, but, so I think we agree a lot, we don't agree on everything.
Thank you.
Welcome.
Yeah, so I just wanted to chime in. I kind of feel in the same position where, you know, I have a lot of questions and don't really have answers. And, you know, I feel like there's the capacity issue, but there's also the types of facilities issue. You know, I understand there's a distinction between the folks who are super dangerous, but also the folks who have very high needs that need just continuous service. And, you know, for example, in my area, there's a individual who lives in Brattleboro who, for example, he stole the company car from my law firm once and returned, you know, he stole it in the middle of the night, returned it the next morning, there was no damage, just went for a joyride. And, you know, a week later, he was found in somebody's living room drinking beer, not doing anything violent. The person came home, saw him, and then he said, "Oh, sorry, I'll see you later," and then left. And there's a number of instances of things like that where, you know, it's not violent, it's not, I mean, it's dangerous for the individual who's doing these things, because someday he may walk into the wrong house, and, you know, that's what I worry about. It's one of the things that I worry about. You know, there's nowhere for him to go, and there's nowhere for him to get the services that he needs, because his situation is, you know, it's not something that can be really resolved. That's who he is, and, you know, he needs help to make sure that he's living a safe life. So there's that concern that I have, and, you know, there's lots of these issues in a number of different communities, and then, you know, we also have the concern about the folks who are super dangerous. And so I'm not really sure where I'm going with my train of thought. It's just, you know, I also have questions, but I'm not sure what the answers are.
Well, Senator, I agree. I think that this example, and I don't want to talk too much about the details, because we could wind up representing this guy. But we've certainly seen cases where courts have determined someone to be dangerous for going to other people's houses, because, as you say, that could be met with a violent response. But and I don't know what kind of living situation this person is in now, but if there were more facilities where there's staffing, and even without being a locked facility where someone gets involuntarily medicated, if more facilities with staffing where people get supervision, could be all that person needs.
Yeah, I feel like what we really need is a facility to increase capacity. You know, I mean, after, as Senator Sears said, after the hurricane and we lost our primary hospital, you know, it's just been a system that's been in shambles. And yeah.
And Middlesex is going to be moving to the new location, double the size, and that hopefully will let off some of the pressure.
Senator Wells.
Well, I agree with the general sentiment that the system is in shambles. I'm always hesitant to go the route of building the highest needs level facility rather than making investments in community mental health. You know, people usually climb to crisis level because they have not gotten the supports and services that they've needed over extended periods of time. So I definitely also just want to point to that. My question for you, Mr. McCullough, is do you view this bill as an expansion of orders of non-hospitalization to a lower level of care?
It's hard to say yes to that, because there's orders of non-hospitalization have a whole range from people who are at Middlesex now are on an order of non-hospitalization because it's not a hospital facility, and but it's a locked facility, so that's like just a little bit below the level of the hospitals. But there are also orders of non-hospitalization where the person is living in their own apartment. They're just told to take their meds, go to their appointments, cooperate with treatment, but otherwise they're free to go to their job, go skiing, do whatever they want, basically. And so there's a whole range.
Okay,
Yeah, the design of an order of non-hospitalization is to give the person the lowest level of restriction that is adequate to their needs.
okay, so this isn't really expanding what's already being done in terms of orders of non-hospitalization.
I think that's right. As I said at the beginning, the criminal division already has the authority to put someone on order of non-hospitalization.
Thank you.
But they don't have a place.
I do have one more question for you, and this comes from S8, which I think you're familiar with, and I'm only asking because constituents asked me to ask. The idea of switching representation of folks who are found incompetent back to the Defender General's office. This is something that was asked of me by the supervising defender in Windham County and the state's attorney in Windham County, both of whom agreed. And I definitely want to hear your thoughts on that and any information you could provide there.
I'm not surprised that the state's attorney wants that. I am surprised about the public defender, and I'd like to talk to them about it. I think that our experience across the state is that it has been successful to have us be doing those cases, and there's some complications, and there's been some adjustments as we get to the new system. But overall, I think that the defendants and the system have been well served by having the shift to legal aid representing those people.
Thank you. And I don't want to speak on behalf of the defender or the state's attorney down there, but it was a question that they had, and just wanted to make sure I transferred here to the.
I know a number of the people in the public defender's office. If you happen to know the name of who the supervising attorney is.
The supervising attorney in Windham County is Mimi Brill.
Oh, okay. I know Mimi very well. I talked to her about that.
Yeah, and if you want to keep me in the loop or not, whatever you want, I'd be happy to chime in on the conversation if you'd like.
Okay, great. Thanks.
Thank you.
Anything else for Jack? Jack, thanks very much, and good luck next Tuesday.
Thank you, Mr. Chairman. I'm optimistic.
Kelly Carroll is the next witness. Kelly is from Bennington.
Good morning, and I hope you can hear me okay.
Yeah, we can. Thank you.
Perfect. So hello and thank you. My name is Kelly Carroll, and I am a concerned impacted citizen from Bennington. I'm here to speak as a mom on behalf of my twin daughters, Emily and Olivia. This is very difficult for me, so please bear with me. I'm going to try scripted so I don't, anyway, I hope I don't come across too scripted, but some of you may know about my daughter, Emily. She was murdered in Bennington on January 18th, 2021 by Darren Pronto. What you may not know is that her killer is currently in the Vermont Psych Hospital with his hold without bail order still intact. And I apologize. Peggy sent me an email saying that you had started earlier and I missed Jared's testimony, and I will watch that. But anyway, so if this is repetitive, I apologize. But thanks to 2021 S3 Act 57, he will be held at the Vermont Psych Hospital until he no longer meets CMS criteria. And then he will be transferred to the soon-to-be closed Middlesex facility. He will live in a non-secure facility with non-violent residents and unprotected staff. Once DMH determines he has improved and they want to release him back to the community, the state's attorney will be notified. So whenever there is a change of custody, they'll get notified. The hold without bail order will kick back in, and he goes back to jail, and the competency process starts again. What you may not realize is that S3 Act 57 created a forensic working group, and I was fortunate enough to prepare in that, or to participate in that process. One thing we were tasked with was to make a recommendation if there is a need for a Vermont forensic facility or not. I know Karen Barber will be in later to talk, and she's much more versed to talk about this. But we couldn't agree, and our report was submitted to the legislature in January. You should have it. It includes multiple opinions and a lot of helpful information from other states, and I hope that you're going to take the time to review it. Just a couple of points that I would like to highlight from this process as a victim's perspective. You've heard about that Bennington case that was spoken about last week when S89 was testified. And throughout that entire process, the Bennington case has never ever been about the victim. And I want you to know that that Bennington case actually began in 2015 with assault. Then in 2016, there was another assault, followed by a second assault in 2016. And each time he was released with stricter and stricter mental health conditions out in the community, virtually no follow-up. And then in 2018, that Bennington case terrorized his neighbors until he committed a violent home invasion where he was threatening to slit their throats. Now, Vermont State Police arrived in time for that one, and they were able to save the victim. And that Bennington case then went into DMH custody. Mr. Valerio's office, the Defender General, who never expert shops, actually had a competent evaluation done and then went and got a second evaluation for not competent. 18 months later, with no notification to the victims, the community, the state's attorney, anybody, he was released back into the community with inadequate mental health follow-up and no protection for the public. His victims found out about their release when the news of Emily's murder broke. For several months, he was allowed to terrorize his Pownell neighbors. Relief from abuse orders and stalking orders did nothing. Multiple calls to VSP did nothing to protect the public and help stop that reign of terror. In November 2020, he made a video laughing at the state of Vermont, bragging about being a murderer, bragging about how he can get away with it because he has his non-competent paperwork and the state can't do anything. In January 2021, which was less than 2 months after that, he murdered my Emily. In November of 2022, his defense attorney said in court that he owed it to his client to keep him hospitalized so he can keep him out of further trouble. So I have to ask you, how much more trouble can a first-degree murderer really get into? That's definitely something to think about, because if his own defense attorney is concerned about him coming out, I think that that says something right there for the rest of us to listen to. And even look at yesterday's headlines about 40-year. You know, where are we going to keep our violent forensic offenders? But anyway, during the S89 testimony last week, there was a question about what type of representation someone going through this forensic process gets. When we finally got to court in November of 2022, he had a defense attorney, he had an attorney from legal aid, he had representation for mental health, and he had a psychiatrist, all advocating for him. And during that court appearance, the judge rescheduled until December so that she could add a guardian ad litem for him so that another person was advocating him. So I just want everyone to know that criminal forensic defendants are very well represented in the courts. And the only time that my Emily was ever mentioned in the 2 years that we have been going through this process was when Judge Corsones instructed me to put a picture of her away in court. So once he no longer meets CMS criteria for acute care stay, what are we going to do with him? According to his court agreement, he gets transferred to the soon-to-be closed Middlesex facility. Doesn't say anything about Essex. It just says he's going to go to Middlesex, and if he's to the point where he is found to be competent or good enough to be released unsupervised into the community, then the hold without bail order goes into place, and he goes back to jail, and we go through the whole competency process again. But I think that what we need to remember is that we're talking about criminal cases, not civil. And this is very difficult for me to talk about because we definitely need a forensic facility, but we have a significant crisis with mental health and the lack of beds for nonviolent mental health patients. So when it comes to that Bennington case, the Defender General and I often disagree, but if you look at the Forensic Working Group report and you look at page 11 on his report, you're going to see his response where he, quote, observed points of agreement and proposed action items. And his number one action item is the establishment of a new forensic mental health facility. And I'm sure that you're going to be hearing about him, but that's just something that we agree on. Also on page 13 of that Forensic Working Group, you're going to find a late submission that was sent in by Jack McCullough from Legal Aid. You heard from him this morning. And other than Disability Rights Vermont, no one else on that working group was able to read that report ahead of time, comment on it, review it, or anything. So when you're looking at that, I just want you to remember that recommendation, that the only other person who saw it and was able to comment on it was Disability Rights Vermont. And honestly, 100% agree with having to put more community resources in with what Disability Rights Vermont said, but please remember that. And then also, throughout the working group, I often heard Jack McCullough make comments, if you build it, they will come. I'm really tired of hearing, if you build it, they will come. Because I would say to Jack, you know what, Jack? They're already here. They're born here. Some of these people have been raised here and they've been part of our communities and they've strayed off track. And part of that is a disservice by the mental health programs that we have for our communities. And then part of it is a disservice based on the system that we have. So I urge you to remember that we need more mental health beds. In April of 2021, Representative Ann Donahue also received a House Healthcare report on forensic mental health in Vermont from graduate students at the Nelson A. Rockefeller Center for Public Policy and Social Sciences at Dartmouth. And I think Peggy has posted both of these. I've sent them to her and she's usually really great about that.
They are on our webpage, Kelly.
Thank you. If you look at page 6, right before the conclusion, and I'm not advocating for jail-based particularly, but on page 6, it does make a note that there are characteristics, I'm going to pronounce this wrong, amenable for adoption of the Southern State Correction Facility from that mental health unit into a forensic facility. So that report went out in April of 2021, and it was submitted to Ann Donahue and the House Healthcare Committee. However, she did not present that report to the Forensic Working Group or even to DMH. Joanne Kortendick, who is another victim that was part of that Forensic Working Group, and you may have heard from before, found this by accident when she was doing research for our presentation in that working group. So I would just request that you take the time to review this report. And Joanne is also a victim who lost her sister Kathleen and has been in the competency nightmare for well over 10 years. And I hope that if S91 gets to testify, an act relating to competency and insanity, I don't know if that'll make it through this year, but if it does, I hope that you call on her for testimony. I did say this was hard. Vermont needs a forensic facility, but we also need services for nonviolent Vermonters. At the beginning, I told you I was going to talk about my twins. A lot of people know about Emily, but they may not know she has a twin sister, Olivia. And Olivia lost her boyfriend a month ago. And his story is not my story to tell, but hers is. And on 4 different occasions in January, she took him to Southwest Vermont Medical Center for mental health help. He was in crisis. He was self-harming. The first time he stayed 3 days. The other 3 times he stayed less than 24 hours. He begged for a bed at the Vermont Psych Hospital, begged for it. Every time she told his nurses the medications weren't working. And every time after that initial 3-day stay, he was out within 24 hours. And the last time within the next day, he committed suicide. I don't know what to tell her. I really don't. And I'm very pleased that there's an act to establish a forensic facility. I have significant concerns that it's going to be the 9 beds at the Vermont Psych Hospital. I know that there's about 5 beds now that are taken up with forensic patients. And it's hard to say, is that why he couldn't get a bed? I know there was another case in Ludlow. I'm not sure. I know there's been a lot of talk about suicide in Montpelier. We had another suicide in Bennington last night. And I don't know how many more times we can decline mental health for nonviolent people because we've got our violent offenders taking up beds at the Vermont Psych Hospital. I can't, I can't tell you if designating those 9 beds to forensics is going to make a difference in that, but it shouldn't be at the expense of non-violent Vermonters. It's very difficult watching her grieve and knowing that and just not really understanding how we can say we're all about community and take those 9 beds for our Vermont community away. And I think if you're going to do that, and you've probably heard this before, I know Jack mentioned it a little bit, but you need to follow it up with some local beds, some local programs and funding, because I'll tell you right now, Bennington has nothing. And I know it's not your committee's charge, but some of these mental health beds that we need, we just don't have, and people are committing suicide, and that's not the answer. I urge you to go forward with a forensic facility, but I also urge you to take it a step further. Make it a forensic hub and a spoke system type of care, similar to what we have with methadone. I mean, I've heard comments about trying to get to people before they get to that level where they need a forensic facility. We don't have that infrastructure in place. We might have some of it up in Chittenden County, and there might be some of it up in in Washington County or up in Berlin, in the Berlin area. But, in the southern parts of the state, we don't have much. Brattleboro's lucky. They have the Brattleboro Retreat. Rutland has a few crisis beds, but we don't have anything in Southwest Vermont. So if you're going to take those 9 beds and allocate them to forensic, make sure you've got something to back it up for our local providers, please. I want you also to reconsider the change of jurisdictional court venue for the court proceedings for the defendants, the offenders that's in this bill. I think it's on page 20, lines 20 and 21. I think that's an additional burden on the victim. This has been a completely traumatic experience, and the relationship that I have with the state's attorney's office and my victim's advocate, and that consistency that we have through that local relationship should not be discounted simply for the convenience of DMH and the criminal defendant. Victims need to be considered. And if you won't remove the venue change for the victims, then do it for the violent offender's family. Travel to court hearings can be a hardship for them too. Many victims attend court hearings, and I think changing that jurisdiction is just one more attempt to silence us. And I think that we need to be remembered. I also, I know you were talking about youth, and this is off topic, but Dartmouth Health is right now doing a feasibility study to consider whether they should accept the state's $9.24 million for a youth psych unit at Southwestern Vermont Medical Center. And I urge you to do anything that you can, because I think, again, if you can get them into services prior to, then they can prevent, hopefully, from being somebody violent that needs this forensic facility. DMH has no public safety mandates in their statutes, and they should. Vermont needs to do a much better job intersecting public safety and mental health. And that starts with statutes for appropriate programs and facilities. So please put a DMH public safety mandate in this. And I also like that some of the changes go into effect upon passage. Last week, you were told it would take 7 to 9 months for some of this to get through the Rules Committee. I hope that you're going to be able to utilize what the state has accomplished and learned from going through COVID and get these mental health improvements fast-tracked through all the bureaucracy. I think if the longer we delay, and just like Senator Sears says, we've been listening to it, we've been talking about it, and we've been just putting it off to the side. So please address it this year. Thank you again for allowing me to be Emily and Olivia's voices, and thank you for your service to Vermont. And I very much appreciate this opportunity.
Thank you, Kelly, very much. Well said and well stated.
Thank you.
Get your advocacy. Kelly, I don't know if there's any questions from the committee. I would like to understand, I don't know if you got to see, you haven't seen Jared's proposal, nor have you seen, I don't think, the proposal from DMH regarding the criteria for admission to the forensic facility. But if you have thoughts on that after you've had a chance to look at them, we'd be happy to hear.
I would be happy to look at them and let you know my thoughts. I didn't, and I apologize for not being,
No,
aware.
that's okay.
I looked last week.
Yeah, things are happening quickly around here. But I do want to thank you for being a voice for victims. And I think too often, as you pointed out, victims have been left out of the equation in this realm. So
Yeah, we are. And I just want to let you know that I appreciate all of the legislators that are concerned about victims. I mean, as you know, I write letters. Some people write back, and I appreciate that. But I appreciate very much the opportunity to have my voice heard. I would love to have been there in person, maybe next time. But just being able to even have the remote is good, is just a fantastic opportunity, and I thank you for that.
well, the situation for both of us is I'm in Bennington also today, so, recovering from COVID. Any other questions for Kelly from the committee? Okay, Karen Barber here is our final witness this morning.
Yes.
And then we'll talk with Emily. With Katie, yep. Go ahead, Karen.
Great, thank you. So for the record, Karen Barber, I'm General Counsel for the Department of Mental Health. I apologize I wasn't here last week, but my understanding is Commissioner Haas kind of gave a brief overview of what we hope to achieve through the bill. So what I was planning on doing was really just responding to some of the comments made by Jack, Kelly, and Jared, but of course available to answer any questions you may have. So I first want to touch on some of Jack's points about what it does and what does it get us. So I think actually it gets us something very different than what we have now. The idea is to create an entirely new level of care. So something that doesn't exist right now. We have a hospital level of care for those that need it, but the target of this facility is individuals who don't meet hospital level of care, but need a more secure setting than either DMH or Dale can currently offer in MTCR or the future Riverside or in the community. So remember that in Dale cases, there is no secure setting. They only have community-based options under Act 248. For DMH, if someone doesn't meet hospitalization criteria, the only additional secure setting we have is MTCR, the Middlesex Therapeutic Community Residence, the future River Valley. But that facility doesn't have the option to do emergency involuntary procedures or involuntary medications. So that does limit who can safely be served in that setting. That was an issue that we raised. We initially asked the legislature for the ability to do EIPs at River Valley. The decision was made that we would not be able to do so. But again, that does limit who can go there. So we are trying to meet a need that doesn't currently exist. I think why do we need to do EIPs, emergency and involuntary procedures, and involuntary medications? From our perspective, that's really key to being able to safely run this type of facility. So this new level of care is focused on those that are both in clinical need of mental health or developmental disability, TBI, some other sort of clinical care, but also remain a real public safety risk, justifying their voluntary commitment in a locked setting. So they have high clinical needs, but they also have high safety needs. And so for their safety, the safety of other residents, and for staff safety, we really need to assure that we have the appropriate clinical interventions available. So I would say those are kind of big picture. How is this different? And why do we need to be able to do emergency involuntary procedures and involuntary medications? I think the other thing to note is that I think there may have been some comment about how do we know who is eligible for an emergency involuntary procedure or involuntary medication. Statute is very clear about when we can ask for involuntary medications. That process already exists. Due process is built into every level of that. They have an attorney from legal aid. They can get an independent clinical evaluation, determine if they feel like they should be able to get these medications, and then the court ultimately makes a decision. In terms of emergency involuntary procedures, there's an administrative rule that governs their use. And our request was that that rule be amended to include this new facility. So again, due process built into every part of that. Every CON, it's called a certificate of need. So when someone has an emergency involuntary procedure, the clinical team needs to fill out a form and justify that use. And that all goes to Disability Rights Vermont as the mental health care ombudsman. So it's also independently reviewed by an outside. So there's lots of due process built into every part of that. And we do think they are important components of the new facility and also what make it unique. In terms of Jack raising an issue with Section 4 about the court, if DMH or Dale believe that the forensic facility is appropriate, that the court shall order it. I hadn't looked at that way. The intent was not that the court couldn't say, no, that's not the least restrictive, or that the person's attorney could argue it's more restrictive than necessary. So we certainly are open to changing that language to reflect that that was not the intent. We really wanted to structure this in a way that, like existing statute, there's due process at every level to assure that that people are not there inappropriately. As to Kelly, I just wanted to note that she was a really great participant in the forensic working group. She had a lot of really great ideas, and I'm so glad she was able to come here and talk to you. I can't comment on specific cases. I do just want to note that just in general, VPCH, the Vermont Psychiatric Care Hospital, only accepts involuntary patients. So if someone was voluntarily seeking mental health care treatment, they wouldn't actually be eligible for the Vermont Psychiatric Care Hospital, but all of our other designated hospitals do have capacity for both voluntary and involuntary patients as long as they meet clinical criteria. So I just wanted to be kind of clear about VPCH holds a specific part in our system. It's only for involuntary folks. And then as to the jurisdiction piece she was talking about, it wasn't entirely clear, but I think what she may have been referring to is kind of one of the foundations of the system, which is that if someone comes in through criminal court, through Title 13, those are 90-day orders, and then the case switches over to family court. And so there may be a change in jurisdiction because the court is not the criminal court where the case proceeded, but instead the family court where the person is in the hospital. And that's because those courts kind of have expertise in the proceedings, and they're very different proceedings. So I think that may be what she was referring to. And then I just kind of wanted to talk a little bit about the comments made by the state's attorney in their proposal and DMH's proposal. I just want to first acknowledge that this isn't going to fix the entire system, and nor is it meant to, right? That would require a lot more work and larger policy discussions that the forensic working group began. But when we're talking only about 9 beds, this is simply a way to begin to address the needs within the system. It's not about building an entire system. And while we hear and appreciate the position of the state's attorneys, we respectfully disagree that their amendment is the right path forward for a couple of different reasons, or that it's a modest change. We actually think it kind of really changes the fundamental foundation of the proposal. So as an alternative, AHS through DMH and Dale has proposed language that tries to address their concerns, but is also mindful of the responsibilities of the custodial commissioners, as well as assuring that folks with clinical expertise are making decisions about the needs of the entire state. And our language also addresses the concern raised last week by Commissioner Hawes about Section 18, which is the rulemaking piece around admission, and our request that it actually be in an MOU format. So I'll review that language in detail in a little bit, but I first wanted to kind of talk broadly. I also think it's important to remember that while we're talking about people who have allegedly committed crimes and may be a risk to public safety, because of their competency and or sanity issues, at that time, what we're talking about, they can't be tried or held responsible for their crimes, and they can't be in correction. So I think it's just kind of important to remember kind of where we're at in the process. So one of our big concerns with the language that the state's attorneys has proposed is ADA, the ADA in Olmstead. So in 1999, the US Supreme Court issued what's known as the Olmstead decision, which was their it was a case about Title II of the American with Disabilities Act. And it required that Americans with disabilities have the right to live in an integrated community setting rather than in institutions when appropriate, meaning we need to assure that people are served in the least restrictive settings possible. Right now in statute, that's really built into Title 18 and everything we do. The custodial commissioners have the expertise and knowledge to make those decisions because they know the different resources around the state, and based on their education and training, they understand the often very complex clinical presentations of the individuals we're talking about. I'd note that AHS has spoken to several different states, and none of them allow the court to have the final decision in admission to a forensic facility for this exact reason. The liability rests with the commissioners, and they need to make the final decision because they're the one that hold that responsibility and defend their position. With all due respect to the court, they're not clinicians, nor do they have a deep working knowledge of the available resources around the state to really make a determination about what is the least restrictive setting. The language as written puts DMH and Dale in an untenable position. If we don't seek treatment in the forensic facility, it means we've done the internal analysis to make the decision that the person's needs don't equate the need of a forensic facility as the least restrictive, meaning we can't justify its use if challenged. But if the court were to be allowed to overrule that, how would the state defend itself? The liability rests with the state regardless of what the court has decided. And so we think that's a really important thing to remember, and why it really needs to rest with the commissioners and the custodians of the individual to make those determinations. The other important factor here is the limited amount of beds. So we're talking about 9 beds for both DMH and Dale clients. It's a very small number of beds. And it means the commissioners need to be able to control who uses them, or else they'll be full in no time and be an unusable resource. Let's remember, we're not talking about creating a new large facility. We're talking about taking 9 precious level 1 beds offline. And so we really want to make sure they're used in only the most necessary cases. We really want to make sure that it's a good use of those limited resources, and only the commissioners are in the position to be able to do that. Judges and prosecutors only see the cases in their county, where the commissioners see what's going on a statewide level. They're in a much better position to manage the small resource and make those determinations because, again, they can see what's happening across the state. They understand all the different cases, not just the one in front of that one judge. And they can also look impartially at the clinical needs of each person. I think we also need to be realistic. If this language was included, every time DMH or Dale decided not to use the forensic facility, the prosecutors would likely ask for it and the judge would very likely order it, which means those beds would be full in no time. So not only does it mean it's a resource that's really unusable, but it presents untenable ADA and Olmstead issues. So we proposed language in an MOU format, which I think you all have in front of you. And we believe the MOU makes the most sense. We think that rulemaking would be overly burdensome and negatively impact the department's abilities to use the facility. We don't need a rule to assure due process because that already exists. There's clear statutory authority as to when someone can be in DMH or Dale custody on an ONH or Act 248 order. The court has the ultimate authority to determine admission, and the individual has an attorney to represent their needs. And then our responsibility as DMH and Dale is to assure it's the least restrictive. What we're actually talking about here is not admission criteria, but how the two departments manage using a very small number of beds to manage an entirely new level of care in the most effective way possible, including who gets prioritized. DMH and Dale need flexibility and the ability to change and adapt as the facility opens and we learn more about how it works. This is even more so if at some point the proposed language in S91 about competency restoration is in the mix. So we're proposing language that requires the two departments to execute an MOU, just like the legislature required DMH and DOC to do back in 2018 in Act 78. We see the two situations as really similar, where two departments have clear statutory authority, but the legislature wanted to make sure there was a clear process in place to outline how the two departments will work together. The MOU makes sense because it allows the departments to change and adapt as necessary, but at the same time lays out clear expectations and requirements of their relationship. These are public-facing documents that are found on websites, so everyone has access to them. And we hear the concerns of the state's attorneys and want to address them while at the same time preserving the ability of the custodial commissioners to make final decisions. So what we did in our proposed MOU language was to add some of the language Jared had suggested to make it clear that when we're establishing criteria for consideration for admission, it would include a preference for those folks that Jared had identified as the most important. So we feel that our language is a compromise that assures that we can uphold our ADA and Olmstead responsibilities while at the same time being sensitive to the needs of the state's attorneys. So in closing, before any questions, I just wanted to note that, you know, there's a lot that goes into the running of a forensic facility, and it's not something that can be opened right away. You know, it takes time to staff and run it. And we think that it's also important to think about the changes in S91 in terms of competency and sanity evaluations. We think those are things that can happen much more quickly and maybe help impact the system while at the same time we're working towards a forensic facility. So I just wanted to really put that on the committee's radar that DMH and Dale believe that there's a lot of important content in S91 that could have real impacts on this system. I think as Kelly noted, there's a long wait for competency and sanity evaluations. A lot of things in S91 are meant to address some of those concerns. So I just wanted to raise that and make sure maybe it was on the committee's radar. So happy to answer any questions. I know that was a lot of content.
Senator Bohosky has a question.
Thank you.
Yeah, oh, go ahead.
Is it a requirement that the commissioner of DMH and or Dale be a clinician?
So for DMH, the commissioner, yes, I can't speak to Dale. I apologize. I am not, I'm the general counsel for DMH, so I don't know the requirements of Dale, but I will say Dale is staffed by clinicians at every level, just like DMH is, who are making these clinical decisions. But certainly I can say for sure that the commissioner of DMH is a licensed clinician.
Currently, but is that actually a requirement of the position?
It's in statute, yes.
Okay, thank you.
So.
I
believe so. I should say I believe so. I'd have to double check.
It was at one time. I know that. I don't know if it's been changed.
Okay, thank you. And then my other question for you, so this 9 beds being carved out of the Vermont psychiatric facility is sort of becoming its own separate entity. Would it be, and I hear and share the concerns about carving out 9 beds when we have so many people who are in need of care that aren't getting it. And I recognize it's only non-voluntary individuals at this facility. But we also just heard testimony that the New Essex facility is going to be twice the size of the Middlesex one. Can some of those beds in fact be sectioned out as a separate entity? So we're not losing them at the Vermont psychiatric care facility. And I understand that the River Valley facility has been deemed to not be, to allow some of the treatment modalities being offered in this bill, but if it were to be carved out as a separate entity as is being proposed at Central Vermont, perhaps that is a way forward that doesn't take beds offline.
Possibly. It's, I don't want to speak out of turn without speaking with my commissioner or the secretary. It was built to have kind of two wings to be able to separate. I think it probably needs some adjustments, but we could certainly be more prepared to speak on that in the future if you'd like to hear on it.
Okay, thank you.
I have a couple of comments and questions. Karen, first, thank you for clarifying a number of issues with the bill. I do want to clarify the competency bill. Whether we'll have time before crossover to get to it or not is really up in the air. But it's definitely an issue that needs to be dealt with this biennium. And if we don't get to it this year, we will get to it next year. It'll be priority number one next year for this committee. Because I do believe it needs to be dealt with. I wish the bill had been gotten to us sooner, and I wish that things weren't as clogged up as they get in the legislature. But I agree with you that it's an important issue. The admissions worries me. When Senator Lyons and I were first talking about the draft before you, the bill before you, S-89, one of the issues was the idea of the memorandum of understanding, which the administration wanted in the beginning. And we kind of wanted rules just to give the legislature a role in who gets admitted, not necessarily individuals, but in terms of what would this memorandum of understanding look like. The only other place that I can think of was a memorandum of understanding between the Department of Corrections and Children and Families on Woodside, which allowed young adults who were in adult court but under the age of 18 to be held at Woodside instead of at a correctional facility. And that memorandum of understanding was pretty clear, and everybody in the legislature had worked on it. What do you envision this memorandum of understanding to be like? Because it's going to determine who can get admitted. And as you know, there are going to be folks in the community who will wonder why this particular individual wasn't admitted. And there'll be people, your state's attorneys, others who will be clamoring for it. And you're taking on quite a responsibility.
Yes. We have talked a little bit about what we think kind of makes sense. We have looked to some other states to see how they've structured it some. Again, we're thinking about it very similar to what Act 78 had required us to do back in 2018 with DOC. And in that case, the two departments sat down and kind of fleshed out real clear criteria about different situations and how we proceeded with things. And then I believe we had to present it to one of the joint committees over the summer for their review. So I guess I anticipated something similar, certainly open to however you think it would best be done. I think the reason an MOU really makes a lot more sense is because we need that flexibility rules. One, they take a long time to kind of go through, and two, they're pretty inflexible once they're there to try to go back and amend them. And so we wanted, given that we're creating an entirely new level of care, we wanted to really make sure we had the flexibility to change and adapt as needed, while also meeting the needs of stakeholders. So we're certainly open to ideas about how we draft the MOU and how we present it to folks for their review.
Yeah, thank you. Other questions for Karen?
Not seeing anything in here.
Thank you, Karen.
Thank you.
Katie, are you with us?
I am. Good morning.
Good morning. Is there a way to draft Section 18 so the legislature has some report back on the memorandum of understanding? I don't know what committees are left. There used to be a mental health committee.
You no longer have the summer oversight committee. But yes, you could.
I mean, we have the Justice Oversight Committee, but
Mhm.
it
That would
could
be one
of the
possibility.
avenues.
Yeah, that would be one possibility. Yes, I mean, you could ask for a draft of an MOU from the two departments and ask that the department solicit, legislative input. But once you've sort of delegated that authority and allowed them to come up with that agreement versus by an MOU, you have sort of delegated the authority. And if you wanted to change your mind, you would have to come back, potentially repeal that language and put something else in place. But yes, there is an opportunity for a legislative check-in and perhaps soliciting opinions from legislative members.
And the state's attorney's position, I heard the administration's opposition to that. But, I don't know where the Senate Judiciary Committee wants to go with this. Whether we leave it for the Health and Welfare Committee to look at. How people get into this facility. It's a real issue. I mean, the first decision is, should we have a forensics facility? I believe we do need one. Second question is, how does somebody get into the forensics facility? What's the process? And is it a court process or is it the MOU that's developed?
I would just jump in and say that regardless of whether you do MOU or rulemaking, the bill that you have in front of you does have a court process in place for the decisions that are made. A court has to review the decision for an individual to go into a forensic facility, and it looks at recommendations of the commissioners, the respective commissioners. What the MOU or rules, or however you want that piece to be decided, is looking at is more specificity in terms of the specific criteria that somebody would have to meet in order to be a candidate for the forensic facility. For example, the risk of dangerousness that individual poses, that isn't specifically addressed in the draft. And those are the type of criteria that I think the rule and the MOU envision addressing.
Would it be possible to redraft and allow be more specificity to the MOU with what you just said?
Yep.
And as well as check back with, if there's a better organization. Right now, I'm thinking joint justice oversight and joint fiscal.
Okay.
And a joint fiscal, because there would be money involved here.
Okay. And you would like that to come back this fall potentially?
Yeah.
Okay.
We'll work with Karen on what the deadlines would be.
Okay. Yep. I can put something together. May I also raise another issue that I heard this morning?
Please.
So Mr. McCullough raised an issue in section 4, subdivision A2. It's on page 7 of the draft. If the commissioner determines that the treatment at a forensic facility is appropriate, the court shall order the person to receive the treatment. I flagged that also as I was doing my walkthrough with the committee I guess that was last week, a couple days ago. And I did have an email exchange with the folks at AHS about my concern, and some language that seems to be more appropriate would be if the let's see, if the court determines that the treatment, if the commissioner determines that the treatment at a forensic facility is appropriate and the court agrees, the court shall. So, and bringing the court as a decision maker back into that piece.
Good. That's good. Are there any other areas, committee?
Not seeing anything, no.
Could we have this Friday?
Friday at 10 o'clock?
Yeah, Peggy. I'd like to get this over to Health and Welfare, so they have time to look at it before crossover.
It looks like I'm in another committee at that time, but I can certainly have the language.
Well,
to
we could, well, we can't change the bishop.
No.
What time would you be available?
It looks like I have a very small window. Let's see, between 10:15 and 10:30, but I'm booked prior to that in Senate Health and Welfare. And
Okay, well,
I wonder
let's
if they
do-
could be flexible.
No, let's do 10:15 to 10:30.
Okay,
And if you can get the amendment out ahead of time, and then we can look at it, and DMH will have a chance to look at it, as well as the state's attorneys and anyone else, and then we can.
sure. And may I ask, in the next amendment with the MOU piece, are you looking to incorporate the piece that DMH added with regard to the state's attorney's language about felonies? Should that be in the
Yes.
MOU?
Yeah.
Yes. Great, thank you for clarifying. Okay, I can have that together by tomorrow to circulate.
Okay, great, thank you. You may want to send a copy to Judge Zone, just so he's aware of if they have any comments.
Okay.
Is there anything else?
No, not that I'm seeing.
Thank you.